Does the Supreme Court have too much power? Should the judges be elected rather than appointed so that they can be accountable to the people? And is it fair that these federal judges should get to be on the bench for life or until they choose to retire?
In this video, I'm going to share with you some of the surprising things I learned about the American court system. It will hopefully give you a different perspective about some of the current events happening in our country today. I know it certainly did that for me. So the Supreme Court has caught the attention of many people for the past few years, and some people have been outraged by the decisions that they've made. They claim that partisanship and bias are directing the court, and that some of these judges are even legislating from the bench. Some people have called for impeachment and court packing and the end of lifetime appointments because of all this. They believe that the Supreme Court has just become way too strong. Believe it or not, the current feelings of contempt that people have for the judges today actually run all the way back to even before the American Revolution. And all those things that I've mentioned, like impeachment, the end of lifetime appointments, and court packing, have actually been tried in our country's history. And during the early years of the American Republic, the Democratic Republican Party, Thomas Jefferson's party, actually even tried to get rid of the whole federal court system. It just seemed to be that the courts had way too much power and were way too politically biased. So then, how exactly did the judicial branch get all the power that it has today? Have federal judges always been appointed for life? And if so, why? And how did this come to be, especially with all of the discontent surrounding the court system? So today we're going to dive deep to find the answer to some of these questions. We'll investigate the original role of the judiciary before the American Revolution, efforts to weaken the court system after the American Revolution, and the chaos and crisis that came after that. And finally, we're going to get to how the judicial branch became a separate, independent, and more powerful branch of the federal government with lifetime appointments and the checks and balances power. After all this, then maybe you can decide for yourself if we need to have lifetime appointments and to have judges as a strong and independent part of our government. So historically, judges in the English courts were servants of the king or queen, and their job was to apply the laws to individual cases. They could be hired and fired at will by the crown. Judges had to balance between different sets of laws. There was the common law, which was law that wasn't necessarily written down, but it was based on tradition and based on the decisions that previous judges and courts have decided upon. So they were not based on explicitly written laws. The other set of laws were called statutes or statutory law, and these were the laws that were explicitly written. So again, judges had to balance between these two types of laws and just find a harmony between them. In addition, whatever decision they made, they had to make sure that it didn't displease the king or queen, because their jobs depended on making sure that the crown was kept happy and liked the way they made their decisions. However, in 1701, the Glorious Revolution happened in England, and it weakened the power of the crown and actually gave judges more independence, and they could keep their jobs even if they made the king or queen unhappy, as long as they had good behavior. However, this was actually applied only to judges in England themselves, in the mother country. Judges in the colonies, including the American colonies, were still very much dependent on the king and queen and could be easily fired by them. As a result, American colonists saw judges as mere servants of the crown, and that judges based their decisions on keeping the king or the queen happy rather than in on protecting people's rights and guaranteeing their freedoms. As a result, many colonists saw judges and the court system as just another way to oppress them and keep them shackled to the king or queen. They believed that the judiciary was actually dangerous to the rights and freedoms of the people rather than as something that guarded those things. This belief was supported by the perception that people had that a lot of the decisions judges had seemed to be random and inconsistent. However, a lot of this was also actually due to the fact that judges in the American colonies not only had to balance English common law and English statutes, but they also had to balance the colonial laws, the laws inside the colonies themselves, the statutes and the traditions there. So judges had a really big job of trying to find harmony between all these different sets of laws. As a result, they had the power to decide which laws to apply to which particular cases, whatever they saw was most relevant. So different judges would make different decisions about different situations. But I think the way it came off to people is that these judges are just making decisions based on their whims. In 1776, Thomas Jefferson said that people thought court decisions were based on the eccentric impulses of whimsical, capricious, designing men. In addition, judges in the 18th century were also not appointed based on their legal expertise, but based on their social and political rank. Some of them actually had no legal training. For example, Thomas Hutchinson of Massachusetts was one such person. He served as the Chief Justice of the Supreme Court in Massachusetts colony in 1760s. At the same time, he was also the lieutenant governor and part of the colony's lawmaking body. And this was all very typical back then. It didn't matter that he had multiple roles and they didn't see the conflict in interest. Because of this, people were even more convinced that judges were biased and held way too much power. So once they gained their independence from Great Britain, they sought to make a lot of changes. By the way, if you're finding this helpful so far, please go ahead and hit like and subscribe so that it can get to more people who will find it useful. Thank you. So after the American Revolution, the former colonists were eager to reform, if not get rid of, the whole justice system and make it more fair. First, they tried to reform the appointments of judges. As state lawmakers wrote their state constitution, they made it so that judges would actually be appointed by state legislatures. In this way, they felt that this would make judges more accountable to the will of the people because state legislatures were actually elected by the people. So state lawmakers believed that they represented the will of the people. Most state constitutions were written so that state legislatures were the ones to set the pay of the judges rather than the executive branch. And the state legislatures also had the power to impeach judges or remove judges based on a simple majority vote. And a lot of the state constitution also set a number of years, set a limit for the time that a person could be a judge. For example, Rhode Island, Connecticut, and Vermont set it so that they would be able to review the judge appointments every single year. In 1787, for example, Rhode Island state legislature completely replaced the state's Supreme Court because they were unhappy with the decisions the court had made in the previous year. So the next thing former colonists tried to reform was the law itself, right? They saw that, okay, there's just too much between the common law and the statutes. And if we made it so that we can get rid of the common law, then we would be less dependent on judges, right? After all, the common law was not written, so it was too confusing and seemed too arbitrary, not clear-cut, and they're the reason why we needed judges to make these decisions. But if things were written down, then that means everyone would know what the laws were and things would be more clear and we would be less dependent on judges. And this was actually a movement that happened throughout much of Europe during the last part of the 18th century. However, the new American states had a unique situation. Not only were they trying to get rid of the common law, but they were actually also creating new laws that in order to build the infrastructures for their new country and their new government. And because state legislatures were made up of people who came and went based on whether they were elected or not, the whole process for replacing the common law or making the whole common law written and creating new laws happened really chaotically and piece by piece. They constantly changed based on who was elected at what particular time. Laws that took time to carefully think through and write were quickly changed or abolished as different people became in charge. In addition, every new law led to even more laws so that they could try to clarify and say how that particular law would apply to different cases. And oftentimes, the new laws were just really rushed and inconsistent. Eventually, people got really sick of it. For example, a South Carolina citizen complained, "For every new law acts as rubbish under which we bury the former." So all of this chaos and confusion that resulted from trying to reform the court system so that it would be weakened and to be more fair actually had the opposite desired effect. Abolishing the common law by turning it into a system of written laws or statutes actually made judges more powerful and necessary because now they were needed more than ever to really interpret how all these new laws would apply to an infinite number of situations. Judges really had to lean more into their power of judicial discretion in order to make sense and bring order to all of the new laws that just kept increasing and changing as time went by. So by the 1780s, Americans actually realized that judges were needed to have more stability in the government. They helped to make sense of the laws and to make them more predictable. Americans realized that it was actually more stable to make sure that state legislatures only made a few laws that were necessary and to leave the interpretation of these laws to the judges to let them figure out how these laws would apply to different situations based on general rules of fairness and justice. Many people also saw the problem with the excesses of democracy. They realized that the legislature's chaotic lawmaking and efforts to make rules for everything, like explicit rules that were explicitly written down, actually had the effect of limiting people's individual rights and freedoms. They put explicit limits on what a person can and cannot do. So as a result, not only did the judiciary become more important and more powerful, but Americans actually now saw them as crucial to having a stable and fair government. In their eyes, the court system had to be separate and independent from the legislative and executive branches of the government so that they would be more empowered to make decisions that were fair and not just based on fads or whoever was in power. The backtracking, flip-flopping, and chaotic law changing of the legislatures as different people became in charge also made it really obvious to Americans then that it's important for stability to have judges that would be in office for a longer period of time and maybe even for a lifetime. So ultimately, this experience of chaos and legislative crisis became the foundation of what we have today, which is a court system, a judicial branch that is separate and equal to the other two branches of the government, comprised of judges that are appointed for life. So that's all for today. I hope this has been helpful to you. Don't forget to subscribe if you'd like to be updated for more in the future. Thank you. Have a wonderful day.